Hey, Jeff, how are you?
I'm doing great today. How are you, Brett?
Good. This is Texas Law Unlocked, giving you clear insight into Texas law so we can move forward with confidence. I'm Brett Pritchard.
I'm Jeff Linik.
All right. Quick note before we get started. Everything on this podcast is for educational purposes and does not constitute legal advice. Texas Law Unlocked is brought to you by the Law Office of Brett H. Pritchard. Jeff, I've been really excited about this one. Every litigator has a trap they've seen someone walk into. Sometimes it's a strategy that looks smart on paper, but then completely backfires. And today we're breaking down a few of those, including one playing out right now in a courtroom. Everyone's watching.
Yep. National news.
Last week, I had been reading an article and I sent it to you. We always like looking at current cases, and
absolutely.
As we've talked about, we've seen a bunch, and we saw this one play out last week. Don't care about the politics of it, but the trial's fascinating, and that's the Charlie Kirk assassination trial. Yep. The defendant's Tyler Robinson. We need to talk about it. We gave a story in our first podcast when we talked about just because you did it doesn't mean you're guilty.
Right.
And we didn't tell the conclusion. I've had a lot of people ask about it. So the story was the man I represented who owned a ranch off of 436, which is the road between Belton and Little River Academy. And between the road and his ranch is a large right-of-way. Now, in Texas, he owns the property up to the road, but the right-of-way gives public easement for anybody using that highway. The state is responsible for mowing the area between the highway and the fence, his right-of-way,
right,
where the right-of-way ends, right? And the state comes through, and everybody owns ranches along there. They keep them mowed because the state only comes through a couple of times. And so if you have a pretty ranch, you want to be able to see your pretty ranch. And so as we talked about, he's in the right-of-way on his land mowing that, and he's got a case of beer on a zero turn, and he gets stopped. And because he's in the public right-of-way, he's charged with DWI. The end of the story is this. The argument was for ours, he was not a licensee on that property, but rather an owner.
Right.
And so he had to be there as to him, it was private, not public. Of course, they came out and said, but he is in a public area, so it's public. We sort of analogize this as you and I were talking to Walmart.
Right.
If you and I go to the Walmart parking lot, we can get a DWI, no questions asked. It's a
we're
public
licensees.
area.
We're part of the public just driving on their parking lot.
Right. But if Sam Walton, the owner of Walmart, is on the parking lot, that's different. It's his property.
His place. He could show up and kick everyone else out if he wanted to.
He could make everybody leave.
Yep.
So that was the argument. And the conclusion of that story was the state had too many other things to worry about. They just let that one go.
That's all you got to do sometimes. Just make it not worth the trouble.
So again, it was, he did it, but
doesn't mean he's guilty.
Doesn't mean he's guilty.
And if they had gone forward, that thing would have probably been tied up in appeals so long.
It just wasn't worth it.
Wasn't worth it.
Anticlimactic ending to an otherwise funny story.
Hey, as defense attorneys, we take our wins any way we can get them. That's a win just as good as any other.
All right. We were talking about Charlie Kirk. So let's set this up. We know the shooting happens. The defense has been arguing that there needs to be a gag order.
Right.
Because they didn't want the prosecutor sharing things and getting out in the public.
Right, because it's already got such scrutiny and they've got a jury pool out there. They don't want them tainted.
Right. And interesting there is that I went to school in Utah, BYU, and the entire population really is between Ogden and Spanish Fork. Really, there's probably 70% of the population of that state is
all along one stretch of highway.
Yeah, and it's within 50, 60 miles. So there's no place to really move the trial. So the defense doesn't want any more of the evidence getting out. So they want a gag order. And then they also refuse to have, they have fought against having cameras in the courtroom.
Right.
Okay. That's the buildup. Well, the state decides in this case that they are going to prosecute this, but they're not going to indict it. They're going to prosecute it on information. Jeff, explain that.
So on a felony charge, you are entitled typically to, well, not typically, you're constitutionally entitled to have your case presented to a grand jury before you're formally charged. A grand jury has to return a true bill of indictment. Then you're formally charged and compelled to appear in court and answer to the charges. Now, you can convict somebody without that because a defendant has the right to waive grand jury, but also prosecutors, as a tactic, can actually file what's called an information, or at least that's what the charging document is called in Texas, and can compel somebody to appear on an information. And that's just done by the prosecutor's office. They don't have to present it to a grand jury.
Now, if they do that, of course, because somebody has to determine probable cause.
Right. So because you don't have the grand jury protections, Texas, you're entitled to a preliminary hearing to put the evidence in front of a judge and have a judge determine whether there's probable cause.
Okay. And who asked for the preliminary hearing?
In this case, it was the defense.
So the defense, who wants to keep everything quiet, says, we want a preliminary hearing.
Which I've done myself many times, but not in cases that are, getting a lot of media attention. That's a big difference here.
Okay, so the state's saying, we want a preliminary hearing. They're beating their
the defense is saying
we want a preliminary hearing. They're beating their hand on the table. We want it. And in this case, it turns out the state says, okay, hold my beer.
That's right.
And so
you want it, you got it.
You want it, you have the right to it, and here we go. Well, we start reading it, and Jeff, all the things the defense didn't want, because they didn't want cameras, they didn't want press, have all come out.
Yep.
And the funny thing is,
by the way, just to preface it, they got the gag order. Not only did they get the gag order in place, the state actually wound up violating it, and they had the state held in contempt for violating it all before this happened.
Right. All the defense had to do was just waive the preliminary hearing.
That's right.
Just say, we don't need it, Judge. We stipulate probable cause.
Exactly.
And instead of stipulating probable cause, and they would have had a gag order, so nothing comes out, they make the state put on the preliminary hearing, and they can't, once the preliminary hearing starts, they can't control what the state's going to put on.
That's right.
And the state puts on devastating.
Oh, it's unbelievable.
Evidence. I mean, they put on the confessions, they put on the forensic reports, they put on all the videos showing he's been at the scene 4 or 5 times that day.
They put on the video of his significant other, and the defense wound up objecting because they can't cross-examine him. And he's sitting there on video talking about, he confessed to me, and they're objecting that they can't cross-examine him. And the judge said, well, it's a preliminary hearing. You're not entitled to confrontation. So that they get this uncontroverted video out there of a guy saying he confessed to me.
And the funny thing is that video would have never been seen by the public.
Never in a million years. It would never have got admitted at trial. It's inadmissible.
And so the state just trapped him.
Yep. Absolutely.
Just trapped him. And so we started talking about it. We've been laughing about the legal traps. And so then I thought that would be fun to tell. And then I wanted to tell the story. And if you're a litigator, you've either trapped someone, or there are times, or especially early in your career, where you get trapped. You walk right into it.
Absolutely. Sometimes we fall prey to it as well.
Jeff, I remember when I was a young lawyer, I had a case where the father wasn't getting, he was the non-custodial parent, and the mother wasn't letting him have his visitation. And so he comes into me, and I said, well, let's file a motion to enforce and hold the mother in contempt.
Right.
Let's put her in jail because she wasn't allowing the visitation to happen.
Right.
We get to the courthouse, and I'm waiting around all day. The judge is hearing all the other cases. They take up all the easy matters first, and by 11:30, I'm finally going to get my hearing. So prior to that, I go up to the attorney and said, listen, you're going to pay my attorney's fees. It's mandatory. And I'll tell you, the attorney, it's Mike White. And Mike looks at me and goes, I'll bet you $50 I don't pay your attorney's fees. And I sit there and I walk away, and I'm thinking, what could he possibly be talking about? I reopen the code. I'm looking through the code. He is going to pay my attorney's fees. It's a shall.
Right.
So we go into court, and I'm sitting there with my client, and all of a sudden the back door's open, and there's a ruckus, and I turn around and both doors are opening. And here comes a lady. She's laying in a hospital bed. There's a IV bar hooked to the bed. There's There's a bag hanging there. The lady's got an IV. She's being pushed in. And I looked at my client and said, "Is your wife sick?" And he goes, "Oh, yeah. She's dying. She's got stage 4 whatever cancer. She'll be dead in 2 weeks." And I said, "What?"
I think that
You're
qualifies as
telling
good
me
cause.
now?
Yeah, right.
We start the hearing, and I have to call my client. I call him. Have you been denied visitation? Yes. Is this her? Yeah. Why is she in the bed? Oh, she's got stage 4 cancer. She's dying. They say she's only got less than 2 weeks to live. I pass, and I'm thinking, this is terrible. I pass the witness, and Mike says to the client, did you tell your children that the mother was dying as a result of punishment from God?
Oh, no.
He goes, "Oh, yeah, she had an affair, and I told the girls this."
Oh, no.
I mean, it goes downhill.
Oh, God.
We get all done. Not only do I lose, the judge says, "Sir, you're about to get as much visitation as you want," because she was going to die, which she eventually did. But not only did I not have to pay Mike's attorney,
You're going to get it. Well, he said you're going to get as much visitation as you want in 2 weeks.
Oh, yeah. You're not going to get any visitation
Right.
now. I'm not doing anything. These kids can spend as much time with their mom as they want.
Right.
And then not only did I not get attorney's fees, my client had to pay attorney's fees, and I had to pay Mike $50.
You lost the bet.
I lost the bet. So I'm going, man, this is terrible. And I got trapped.
Hey, you got to respect the game, though. As attorneys, that's always the most exciting thing. Whenever you can just do one of these and
When I remember
someone.
being so mad. I was mad. I thought, how did I get roped into that? Because I didn't. The problem is when you're thinking legal traps, I was looking at the law, looking at the law. Never in a million years would I have thought the facts would have been in such a way
Right.
that I could have been trapped by the facts. So
Right.
you can be trapped by facts. You can be trapped by the law. So I have several we can talk about. I know you have some. So
I got a number.
all right.
I can start with a pretty easy one. It's the only case I ever won on a directed verdict, and it was a misdemeanor case. And so I had a client that he and his girlfriend took a trip from Texas to Florida. I don't know if they were going to the beach or the Magic Kingdom, but apparently it wasn't very magic because they got into an altercation in Florida. Actually, it wound up being a felony. So I think it was probably Texas's equivalent of an ag assault. So he winds up getting arrested in Florida, makes bond, and I don't remember exactly if it's an actual protective order or if it's just a bond condition, but he's not allowed to basically go to her house. So they make their way back to Texas, of course, and their relationship is still tumultuous and breaking up. So he just can't help himself. So one night he just goes over to her house uninvited, and she calls the police, and he gets arrested, and he gets charged with violation of a protective order, which is a misdemeanor offense. It's only a misdemeanor, but he is actually remanded without bond because he's stalked her, assaulted her, and then violated and stalked her. So they kind of considered him a danger. So they actually remanded him without bond on a misdemeanor charge. And it so happened that when I made my appearance in court, they had a trial docket coming up, and he was the only guy in custody.
Did he have was there a protective order, or was this a protective order out of Florida, or was it just a bond condition out of Florida?
I can't remember exactly. I want to think it's just a bond condition, but
Okay.
But if you read the Texas statute, it says violation of a protective order, but it doesn't make a distinction. So if there's a bond condition that says you can't have contact, it would still be a violation.
Okay.
And so I make my appearance, and I'm thinking, well, maybe I can try to get him out of custody to get a bond set, because you're under Texas Constitution, you're generally entitled to that. But they have a trial docket coming up in a couple weeks, so I think, well, why not just see if I can't try the case? And so I set it for trial, and I wind up doing some research. And interestingly enough, there's this weird quirk in the law where if you're going forward on that charge and the order is from another state, I think it has something to do with the full faith and credit, or Chapter 88 of the Family Code, where there's the international or the interstate compact of protective orders. It says that you have to plea specifically in the charging document the order that was rendered, that it was valid jurisdiction, and then you have to include the exact language of the provision that was violated, and there's case law that says not doing that is a fatal variance. There's no curing it, and so I just set it for trial and keep my mouth shut, because all they pled is, he violated an order issued in this state out of Florida is all the charging document said. And so we get there, they present their case, and they rest, and I bring a motion for a directed verdict and show the judge the case law, and had no choice but had to issue a verdict of not guilty. And my only regret in that case is I didn't sit there the whole. I didn't know for sure that the judge was going to do that, so I kind of tried the case just in case the judge wasn't going to, which probably would have been a loser of a case. But I would have really liked to just sit there reading the New York Times, doing crossword puzzles the whole time. That would have made it even better.
Well, there you go. You trapped him.
Yep.
So you bring him in again. Here in that situation, the law's in your favor.
Yep.
Because the state does it wrong.
Yep.
I remember a case one time. I had a juvenile case. I get a client who's charged with a juvenile crime. Now in Texas, juvenile is not a crime. It's a petition engaging in delinquent conduct.
Right.
And the way they do it in Bell County is that the probation office, who does a lot of the juvenile work, prepares information that information is used by the state to prepare their petition. So, and it's not a formal information like we were talking about in the Charlie Kirk thing. It's just an information packet.
Right.
Well, that information packet is turned over in discovery, so we have it. The state has it. And typically the state prepares the petition, but then because the information has much more detail, everybody just uses the information sort of as a shortcut as they're going through trial. Does that make sense?
Mm-hmm.
And so they prove up the case. Well, the information in this case says that this happened in 2015. But the petition has, I guess it's some sort of error, because instead of 2015, it says 2016. So it's a year off.
Right.
So but the petition is the controlling document.
Exactly.
The crime has been alleged in the petition, or the delinquent conduct has been defined in the petition as happening in 2016. Well, the prosecutor in this case starts proving up the case, and without thinking goes through this crime, and it says, did this happen on, we'll call it April 1st, or we won't say April 1st because it's April Fool's. So let's say this happened on March 15th, 2015.
Right.
And it's just an innocuous question. She says, yep, this is when it happened. And they just go through the whole thing of everything that happens. Well, I realize that it's wrong. As I'm looking at the petition, look at my petition, because I realize they didn't prove up what's in the petition, but I don't say a word. Now I know what's wrong, and I just let them do their whole case, and they put on everything, and they call their whole witness, and then we get to the end, and they rest, and I said, well, and I've been an attorney for a while now, and so I said, Judge, when they say they rest, does that mean they're done presenting evidence? He looks at me and he goes, Mr. Pritchard, you know what rest means? Yes, they're done presenting evidence. And Judge, I know that I probably know the answer, but I just want to make sure of this. They can't reopen the evidence. Is that right? Mr. Pritchard, you know what resting is. They've closed, they've rested, they can't put on any evidence. All right, Judge, I thought so. I said, well, I'm going to ask the court for a dismissal and a directed verdict. He goes, what are you talking about? Well, Judge, if you look in the petition says that this crime happened on March 15th, 2016. But I would challenge you to go back and look, Judge, that they have tried to prove it up using their information sheet, their shorthand packet, and they've proved up March 15th, 2015. And Judge, you can go back, and he says, the reporter, is that true? And the reporter goes back, yes, Judge, he said March 15th of 2015. The judge smiles, and he says, State, defense, come on back to our chambers. We go in the back, and he gets there, and I walk in and that prosecutor is fit. She is madder than mad. She's yelling at me. She's pointing at me, telling me, you should have told me then. I could have corrected this. And the judge...
That's exactly why you didn't tell her.
That's right. The judge looks and says to the prosecutor, I almost said her name. I should say her name because she got in trouble. But the judge says to her, Susan, that's not her name. Susan. He says, he's too busy kicking your ass to do your job too.
That's right.
It was the funniest thing. And she was mad. He goes, and he tells her, hey, he's not going to have a choice. I'm not going to, as a judge, I'm not going to have a choice. I'm going to have to go get a dismissal. But don't worry, Susan, this client will be back and you'll be able to get it, or this juvenile will be back and you'll be able to get him next time. But it was really funny. Trapped him.
Yep.
In that case, they'd gotten the facts wrong.
That's right.
It wasn't the law. Well, I mean, the law was that you have to prove up.
Sure. They had a fatal flaw in their pleadings.
Yeah. Well, no. The pleadings were correct. It actually happened in 2016, but they proved it up in 2015.
Right. The way they presented it to the court, the evidence that was on the record.
Correct. So they just proved it wrong. So another legal trap brought them right in.
So the great thing about being a defense attorney is you get to keep your cards played close to your chest, and sometimes that has prosecutors worrying about what they're missing in their case, and sometimes that can be used to your advantage. And I've one time laid a trap for a prosecutor in a case that I had that was a burglary of a habitation case, and there were two co-defendants. I was representing one of them, and for whatever reason, the state never joined the cases together, so they wound up getting tried separately, and my guy wound up getting tried first. And this is some time back, it was before Ring doorbell cameras were common, but the particular home that was burglarized did have somewhat of a security camera system, and the front door camera was very high quality, high resolution, but the other cameras were very low. And they had a camera that picked up not my guy, but the co-defendant going up to the door and ringing it and trying to see if anyone was home, then walking away. And then 10 minutes later, two guys come around the back, but you can't exactly make out exactly who it is. But unfortunately, the case against my guy was strong circumstantially because they later caught him in his car with some of the stolen items. And then the other part of the problem is the police bring him in to interview him, and he was dumb enough to talk to the police. We've said it many times on this podcast, don't ever talk to the police. So he tried giving some explanation because his car was seen in the area. He tried to say he was out there doing lawn work or mowing someone's grass, but he couldn't say who. So it was a very, very strong circumstantial case against my guy. But my guy just didn't want to take a deal. He was convinced he was going to beat this. And so even against my advice, we wind up trying it. But then that got the prosecutor worried. You know, what am I missing here? And so even before the trial, she actually comes up to me and says, I know you don't have to tell me this, but what evidence are you planning on presenting, or what witnesses are you calling? And I just told her that's for me to know and you to find out. And so we do the jury selection and we start the trial. Interestingly enough, my client's dad actually happened to be a city council member. I'm not going to say what town this is. It's somewhere in Texas, but I don't have anybody with him. The gallery is basically empty on the first day of trial, and the state doesn't invoke the rule of witnesses, so the witnesses don't get sequestered. So starting on day 2 of the trial, and on day 1, they wind up presenting the video evidence of the high resolution of the co-defendant in 4K glory up there at the front door. So in day 2 of the trial, I call him up and I have him come into the courtroom, into the gallery, and sit there right in the front row in front of the jurors. And so they start the second day of trial, and the jurors are kind of looking over there, and they're seeing the guy that they just saw on the camera. And so the state finishes presenting their case, and it's fairly rock solid against my guy, but call for a recess and start conferring with the prosecutor, and she is wondering what the heck the co-defendant's sitting there doing, and she's worried that I'm going to call him, and she's telling me, you're not allowed to call a witness just to impeach him. I said, who says I'm going to impeach him? And so she thinks I'm going to call him, and he's going to get up there and say, sure, I did it. That's me on the camera, but it wasn't this other guy. It was another friend of mine. So she winds up actually offering me a very nice deal. My guy had a prior, so he was enhanced. So she winds up waiving the enhancement. We got a much better deal than we would have got otherwise, but never in a million years was he going to get on the stand and admit that he did anything. But the prosecutor just got so into her own head that she was convinced, just because, like I say, you could lay lay that trap for them and make them worry.
They don't know. See, Jeff,
Yep.
the great thing about criminal defense, and I tell this to my clients all the time, when the reason you don't talk to police and the reason you don't talk to the prosecutors and the reason we don't tell prosecutors what we have is because the state, I always say this, they have this much.
Right.
This much is what they have. The evidence they have is in that box. And we know everything in that box.
Right.
Through discovery. We can review everything. The defense attorney knows this much. And we use the stuff out here to poke holes in this box until we can make that box small. If we can make it small enough, we win. That's the strategy. That's where the traps fall.
Exactly.
Because we know what they don't know.
Exactly.
And when we know, then it puts its head. That's why receivers in football always have an advantage over the defensive back.
Right.
Because the receivers always know their route.
Right.
They always know where they're going to go. They know where they're going to break. They know what direction they're going to go.
The defenders have to react.
Right. Defenders have to react. In our case, there are times when the state will trap, like in this case with the defense of the Charlie Kirk case we're talking about.
Right.
But I think more often than not, as defense attorneys, we're able to trap the state. And in the case, in the Charlie Kirk case, the defense sort of, I think any good defense attorney would know that's a trap you're falling. And I'm not saying they're not good defense attorneys. They may be fine. I don't know who they are.
Sure.
And maybe they have another plan. Maybe they're setting a trap.
Maybe there's a logic to it. In fact, one of the things I was thinking is my assessment of the case is their only hope is trying to get the death penalty off the table. And unusually in this particular case, the family doesn't want to go through the rigmarole of a trial. From what I've seen in this, they kind of do. They want the information out there because there's a lot of theories floating around. It may be that they wanted to get the preliminary hearing out of the way to get that out there. So, okay, that maybe quell some of the conspiracy theories, and now the family is not necessarily going to be gung-ho about trying it. So that's the only logic I can see to doing it. But other than that, it doesn't make sense to me.
Yeah, I can't see it. Every time I read those stories and I read what evidence came out, I'm just going,
yeah, it's just it's devastating.
And the funny thing is, I think after that first day, had I been the defense attorney, that first day I would have stood up at the end of that trial. I would have stood up the minute they put the lead investigator and they started showing videos that no one had seen, and they put all those videos out there. I think as the defense attorney, I would have stood up and said, Judge, we're going to admit probable cause.
Yep, absolutely.
We'll concede probable cause here.
Absolutely. Yeah. Who knows? I mean, the only other reason I can think of is maybe their clients just thinking he's going to somehow beat this, and maybe they need to show him the evidence try to work out some deal. But you bring up a good point about what prosecutors know and what prosecutors don't know. And I had another case actually not that long ago, working for our firm, where we had a case that had the prosecutor fall into a trap because of something they don't know. So we had a case where we had a gentleman that was accused of improperly touching his daughter. Turns out he's a very religious guy, and she had some medical problems, and he would go into her room and pray over her at night. But what wound up happening is CPS got involved, got him out of the home, and then they wound up bringing him to the police station. He thought he'd go there and just kind of straighten things out. Unfortunately, they brought in this FBI trained interrogator that kept him in a tiny locked room for about 6 hours and practically all but waterboarded the guy. Flat out lied to him, told him that his daughter had told him things or stated things that he did that she never said, and basically told him his only way out of this is to admit what he had done and apologize for it. So they finally get him on video making, this sort of I'm sorry, and they try to use that against him. But we had represented the family because there was originally a CPS investigation. So we had said, our client's not talking to anybody after this interrogation, but the mom and the daughter are not talking to anybody. And the daughter, of course, is going to be the complaining witness. That would be the star witness at their trial. And so state never really had the opportunity to talk to her to see what she's going to say or not say. But they felt confident enough. They thought they could win this case just on the strength of the so-called confession. And so we start the trial, and in our opening, I actually hold up the indictment that's in there where it says, on about such and such date, he did this, that, and the other. And I said, ladies and gentlemen of the jury, the state is not going to produce one witness that's going to come in here and testify that they have knowledge that this happened. And so inevitably they wind up calling her, and they ask her about all sorts of other stuff that's going on in the house. What kind of started this is she had a friend sleeping over, and they were in her bedroom, and she thought she saw somebody put a camera underneath the door, but wasn't sure who. It could have been her little brother just playing with a phone camera. So they ask her some stuff about that, and they kind of go right up to the allegation, but stop short and never ask her if anything happened. And as a defense attorney, sometimes one of the best things you can do in cross-examination is not to cross-examine. So I just say, we've got no questions. Get her off the stand. And so they wind up closing their case out. And the problem they have is there's a very old common law rule called the corpus delicti rule, which basically says the prosecutor first has to prove that a crime occurred before you can use a confession to establish that the defendant committed the crime. And I said, Judge, if you take this so-called confession out of the equation, they've not presented any evidence that a crime occurred whatsoever. And so they, in the words of the great Key and Peele, you done messed up, A.A. Ron. So they got hoisted on their own petard on that. Now, I said that I've won one case in my career on a directed verdict. The judge did not grant the directed verdict in that case because there is no way in Texas a judge that gets elected is going to have the headline of setting a child abuser free. But we wound up presenting it to the jury, and under the circumstances, they saw how coerced the so-called confession was, and we got an acquittal regardless.
Jeff, I'm about to say something to because you just jogged my memory on something, or you made me realize something. You said there's no way a judge is going to not allow a child abuse or going to not grant a directed verdict on a child abuser. He's going to make the jury do it. I have a common saying. It's very common at my firm. Anybody that works for me knows this, and I tell my clients this all the time. Judges hate when I say this, but it's the honest truth. Jeff, what is the primary job of a district judge in Texas?
Get reelected.
To get reelected. If I have said over and over and over, when you want to know how a judge is going to rule in a case, how is the judge's ruling going to impact him or her in the press? Because their primary job is to get reelected. They want that job. They got it for 4 years, and they're going to have that job in 4 years if they can get reelected, because there's only so many people that can have the job. Well, in your case of a child abuser, the judge doesn't know those people. The judge isn't going to stick his neck on the line for anybody. If in that case, I don't care where you were, what I know what county you're in at the time. I don't, but that's immaterial to me for our conversation here. If a judge believes that he's going to make a ruling, and that ruling could make the newspaper and put him or her in a bad light, the judge isn't going to rule that way.
Ain't going to happen.
It's not going to happen. So I have clients,
especially on some technicality that nobody in the world other than lawyers have ever heard of.
Right.
All the headlines are going to be is judge sets child molester free. That's all everyone's going to read.
Right. And they're not going to go that way. And so I tell clients this all the time. That is actually a calculation we take to our clients, and we tell them, hey, you're expecting the judge to buy what your argument is, when if he buys it and something else were to happen in the future, Fox News and CNN are going to come out and say this judge had let a child molester go and he ended up molesting another child, and he will lose his election.
Exactly. And actually that case was instructive because my co-counsel in that instance was a younger attorney. She's experienced now and turned into a great litigator. And I tasked her with finding the case law on that. And the case she found was spot on. I mean, it was almost identical to ours. I mean, it basically put the judge in a box where he had to dismiss it. And I turned to her, I said, heck of a job, but watch this. Don't get too excited.
Yeah.
And then what winds up happening is we present our argument, and the judge kind of turns to the prosecution and says, do you want to take an hour or two recess to do some research and give you some reason to not grant this? And the prosecutor who also works for somebody who is an elected position, and that's their first job as well. She knows the game full well, so she just says, "No, Judge, we're not going to do that." And the judge says, "Okay, I'm going to deny the motion." Then.
Yeah, the judge, because they know the judge.
Absolutely,
they know the same thing. It puts the judge in a terrible position, and the judge isn't going to do anything. All right, I remember a case, Jeff. Now this one is completely different. It kind of makes me laugh. We get a client that he and his wife are going to go through a custody case in a divorce. And I go in and I file. This was back when you used to file a divorce, and if you had the child in your possession, you filed the divorce, and you would get a temporary restraining order that says the child couldn't be removed from the child's current place of abode without court order or agreement of the parties. Kind of what's in our standing order now. Well, my client has possession of the child. They're doing week to week, and he happens to have the child for the week that he files a divorce. And so they switch every Sunday, or they're supposed to switch every Sunday. Well, my client files the petition when he has the child, the TRO's in place, and because he's there, I have the father, the custody can't switch to the mom, or that's what the order says, right? So Sunday comes around, and I get a call from the opposing attorney on Friday, who says, they need to switch on Sunday, and I tell the opposing attorney, I'm sorry, the TRO is what it is. I'm not going to violate the TRO, and we're not doing it. So that's on Friday. So clearly, that attorney knows that my client is represented by counsel. Well, this attorney on the other side, young attorney, I don't know what she's thinking, but she shows up at my client's house on Sunday to pick up the child. And my client calls me, and I said, tell her no, you can't pick up the child. No, we'll see you in court. And our court's Tuesday or Wednesday. Well, when we get to court, this lady is fit to be tied. She is madder than mad. And she comes in and sees me and says, on Sunday, and I knew she had gone over there. On Sunday, when I went to pick up the child, I was on the porch and he told me to get the F off the porch, uses the F word. And I said, that's bad. I said, man, that's bad. I bet the judge is going to be mad when he hears that. Well, I couldn't believe it, but we start the hearing, and her opening argument, she tells the judge, I showed up at Mr. Pritchard's client's house, and when I'm on the porch, he tells me to get the F off the porch.
Gee.
And the judge looks stunned because an attorney is not allowed to speak to someone who
is represented by counsel. Absolutely.
Number one. And number two,
you can't insert yourself in a case like that because you can't be a witness and an attorney in the same case.
She's now inserted herself as a witness. So he goes, Mr. Pritchard, your argument. And I said, well, Judge, my argument is I have told my clients that anytime opposing counsel shows up at their house, they may use a phrase with the iteration of the F word anytime they want. and it devolves into something funny. The judge and I are both sharing the F word back. Mr. Pritchard, I'm tired of you saying F, and he said the F word. And I said, Judge, I'm saying F. And we're going back and forth sharing the F word. And then finally I said, Judge,
I just say, I'm not going to say my client's exact words, Judge, but it involves some variation on the Reproductive Act.
Yeah, something like that. Anyway, she has now realized that I have said, I bet the judge is going to, I told her beforehand, I bet the judge is going to be mad when he hears about it. I've goaded her into saying it. Then I get to also then say, Judge, also, by the way, I'm going to have to call this attorney to the stand to testify about what she saw when she did it, and she can't be a lawyer. And Judge, I would have you remind counsel that if she decides to continue representation at this hearing, I'm going to have to send her to the bar, but I'd also remind the court that the court is also an attorney and mandatory to report this. You're also going to have to report this to the bar. And the attorney on the other side, eyes get wide, and she says, Judge, I think we need to pass the hearing today, and we'll extend the TRO so she can get new counsel. So we were able to keep custody of the child. Now to all those, I really do not recall whether ultimately we won custody a year later or not. That's immaterial to the story. The story is we did get that passed, and I did trap her by convincing her to, oh boy, I bet the judge is going to be mad.
Certainly got off to a good start. Boy, she really created her own trap in that one. That's the great thing about being a litigator is it's the adversarial process. You're engaged in a battle of wits, and sometimes the other side shows up unarmed.
You just don't know sometimes.
Or as I like to say, sometimes you set the bar so low it's on the ground and they still trip over it.
That's right.
She self-owned herself on that one. I had one, this one is actually recent, where I actually got I goaded the prosecutor into partially making a defense argument in closing. So on this one, what I like to use as an example, and I give credit to there's a YouTube attorney called Briefing Attorney. And he has the concept of kissing the ugly baby versus broken leg facts. And so as lawyers, it's important to distinguish the two. And so kissing the ugly baby fact might be something like your client's charged with intoxication manslaughter, and he has an accident, some passengers in his vehicle die, but he flees the scene of the accident. And so you're stuck with that fact. It's inconvenient. It's kind of like a politician just having to kiss an ugly baby. And so you've got to be able to try to spin it, explain it, massage the facts a little bit, argue to the jurors and say, hey, look, yes, it's unfortunate he did that, but I mean, I haven't had to go through that experience. He was in shock. He didn't know what to do. And I'm sure he regrets the way he handled that. Versus a broken leg fact, as the briefing attorney likes to explain, is if it comes out that at the time of the accident, he was going 132 miles an hour. There's just no way you can spin that. And trying to just calls attention to it and actually makes it look worse if you're trying to justify the unjustifiable. And so one of the things you can do as an attorney, because it's very important to distinguish the two and make sure you handle them properly. If you can force the other side into making that kind of error, then that's good for you. So we had a case recently where we had a guy accused of molesting his stepdaughter, and it's just one of those stories that kind of tends to grow. Initially, by the time it came to trial, she said there was this constant abuse probably happening 3 times a week right there in the living room. Right there on the living room couch, apparently, and you kind of had her do the math on the stand, and we're probably talking hundreds and hundreds of instances. But as it turns out, in the home, there were cameras that were set up to record the living room, so you would absolutely see this happen. It would be captured on video. And the other little sort of quirk about this case also is when I was cross-examining the alleged victim, the prosecutors, every time I'd ask a question that she thought she was giving a halfway decent answer to, the prosecutor's sitting here nodding along like this. And I was about this close to actually objecting on the record and said, Judge, the prosecutor can't be sending signals to the witness.
Which, by the way, in a subsequent trial, those same 2 prosecutors that were doing that, in a trial that was by Bobby Barina, did get in trouble.
Okay, yeah.
A couple of times.
Yeah, well, my thing is this. We were in a very small courtroom, and the jurors were, I could tell out of the corner of my eye, the jurors were seeing what she was doing. Mm-hmm. And I was just in the zone on the cross-examination anyway. And and that's actually the thing about a good cross-examination. It doesn't matter what the witness answers. It's the lawyer testifying. Right. So her nodding along wasn't actually hurting me. And I'm actually glad the jurors saw it. But that's an important point because it'll come back later. So anyway, so then the police officer testifies, and it's just the worst handled investigation you can imagine. The guy had just made the detective. This was like the first case that was handed to him. He didn't do any investigation. He set up a forensic interview, closed his investigation out in a week, and issued an arrest warrant. Didn't look at any phones, and the state's trying to say, well, it's hard to get a search warrant. You don't even need a search warrant to look at the cameras. The mom was right there. She could have given permission.
And would have.
And 100% would have, absolutely. And they tried to spin it, well, maybe, how do we know he didn't turn the cameras off, when this was going on? Well, if he was surreptitiously for 30 minutes, 3 times a week, turning cameras off for no reason, that would be just as good incriminating evidence. So it was just this absolutely inconvenient fact for them. Not just inconvenient, it's terrible for them. And I'm just hammering them in my closing. And so they just can't help themselves. So the second chair prosecutor, when she comes up for the rebuttal, she starts trying to address this to the jurors, and she starts saying, well, gee, ladies and gentlemen, it really actually, I agree. It would be nice if we had that camera footage. And I'm kind of stunned that she says that. So I do what she did. I start nodding along. And she's like, and then we would know for certainly, for to a certainty, exactly what did and didn't happen. I start nodding. I start gesticulating. I'm like, yes, absolutely, I agree. And then she's like, and yeah, we would have every instant recorded, and we would know how bad it was, and we would know if she was telling the truth or not. And I'm like, absolutely. And then finally she goes, but we don't, because the defense could have presented that camera evidence, and they chose not to. And I said, nope, stood up and objected. And I said, first of all, my client was excluded from the house by CPS the moment it was reported, had no access to the cameras. So I said this right in front of the jury. And I said, Judge, she just argued facts that are not in evidence. So I want that stricken. I want the jury to be instructed to disregard that, but only her last sentence. So everything else she just argued about how bad it was, the jury can consider that, but they can't consider the fact that my guy didn't have control over it. It wasn't his fault.
Well, the funny thing is that we did get a not guilty on that case, and because they didn't have any evidence.
Right.
They just couldn't prove anything. Well, these legal traps they happen, and the weird thing, Jeff, a lot of times we kind of see them coming.
Right.
We kind of lay the trap.
Right.
I remember one of our cases recently, we talked about it in one of the other podcasts where you and I were talking, and I'm not going to get the whole thing. And I said, Jeff, let's do this. And it doesn't matter what it was. I want you to go do A, B, C. The prosecutors are going to do 1, 2, and 3. Boom, we got them.
Played out exactly as we planned it.
Yes. You come back that afternoon and goes, it went exactly like we want. In front of it, we ends up with the mistrial because we did it right in front of the jury.
Yeah, it was almost as if it was scripted the way it played out.
Right in front of the jury. I remember one time, you and I used to have a law partner, Ryan, and Ryan had been accused, and we still don't know how because it wasn't his wife, but he had a protective order against him, as you recall.
Right.
And there's a special prosecutor prosecuting for family violence, which we needed the CPS case to go so that we could use the evidence in that to go to the criminal case. CPS calls they file their petition, and we go to the hearing. I represent Ryan in the CPS case. Grant Kinsey, who's now a district judge up in Coryell County, represents Ryan in the criminal case. So we're both doing the case together. We show up to court, and the prosecutor says, well, where's Mr. Lawton? Now remember, his wife is the alleged victim. I said, oh, well, I talked to him today. They're down shopping at the Domain. He and his wife taking the day to shop. Well, is he not coming today? Well, no, you didn't subpoena him to be here. And she's like, well, she thought she was going to have Ryan there.
His wife
there. They're down shopping. And then she starts the case. And so she brings in a deputy. Now, I'm no fool. I know he's on, they had to provide it. He told me he's been subpoenaed, so he called me up. And I read the entire report to him. We read it together, the entire affidavit. And he goes, Mr. Pritchard, it's not possible that Ryan could pull her down the stairs. It's just not possible. And so I'll get to that in a minute. So I said, okay. And he tells me why. I said, oh, okay, I get it. Well, the prosecutor calls him to the stand and goes through the whole, did you see this? Did you see this? Did you saw this in the evidence? And he just says whatever she asked. So then it's my turn to cross-examine. And I said, now, you just testified that the affidavit says that Ryan grabbed her by the hair and pulled her down the stairs. Did you testify that was in that report, in the affidavit? Yeah, that's what's in the affidavit. I said, have you been in the home? Yes. And do you believe it's possible that Ryan could have pulled her down the stairs by her hair? And he goes, no, I don't think that's possible. I said, do you think that because you know Ryan, he's your friend, you think that his personality? He goes, no, Mr. Pritchard, The home is a one-story home. There's no stairs. And I started laughing, and you can see the attorney going,
he could be the meanest SOB in the world. There's no way he physically could have done that.
So then the prosecutor, she's just beside herself. She's like, where did this come from? Maybe this is the wrong thing. She's like, so then the judge, though, is trying to help her out. And the judge is like, well, sir, was it possible he pulled her by the hair down the front porch? She goes, no, they live down a hill. The front porch is there's no step. And I just took a guess at this one. Well, how do you know there's not a step? He goes, I'm the one who tiled the front porch. And then he says, well, what about a back deck? There's no back deck, Judge. So trapped her because in that case, we had taken the time to talk to the detective prior, to talk to the witness, and knew that the story just didn't match up that was in the affidavit. We knew we were going to win the case. Once we had that, then we took that transcript, sent it over to the special prosecutor DA, and the case was dropped completely.
Right.
No criminal charge, no CPS case. So just another trap.
Yep. Those are beautiful. I love it when a plan comes together.
Yeah. Well, that's probably all the time we have. Jeff, I enjoy criminal defense. I enjoy our civil practice as well, because I find that legal traps come in all types of cases.
Absolutely.
And, even the best attorneys will be trapped on occasion. There will be other times in our careers where we will fall into a trap unwittingly, unknowingly.
Happens to everybody at one point or another.
It does. But I will tell you, I look for those things in every one of my cases.
Yep.
And more often than not, we're able to use that to our advantage.
We're usually the ones snaring the other attorney when it comes down to it.
Yeah, we are. So I guess what it comes down to is that's why it's important to hire counsel. If you have a criminal case, if you have some sort of family law matter, if you're facing a challenging legal issue, now is the time to hire counsel. I would encourage you to reach out to our office, make an appointment. You can call us at 254-501-4040. We'll get you a free initial consultation. You'll be able to probably talk to either you, Jeff, or me, and we'll be able to help you.
We'll sit down with you and we'll go over whatever your legal issues are.
All right.
Free of charge.
Well, this has been Texas. This has been Texas Law Unlocked. I forgot the name. This has been Texas Law Unlocked. I'm Brett Pritchard.
I'm Jeff Linik.
Have a great week.